Hello everyone, my name is Esmeralda Flores. I work at the ACLU of San Diego and Imperial Counties, which is the American Civil Liberties Union. Um, and I'm gonna present today on a border update and just kind of like a policy context of what's happening here between the US and Mexico when it comes to immigration policy. So for those of you who aren't familiar with the ACLU, the ACLU is a nationwide organization. To keep it simple, we defend the rights that the Constitution provides to everyone in the United States, even when those rights aren't the most popular. Those are fights that we take on, even in those cases. So I just wanted to remind or let you know that the Constitution protects everyone regardless of their immigration status in the US. Some of these rights are the right to be treated fairly in court, the right to free speech, to religious freedom, to remain silent, and the right to legal counsel in criminal proceedings. Unfortunately, when it comes to people who are going through the immigration system, even though they do have the right to have legal representation, they won't be provided one by at the government's expense as they do in criminal proceedings, even though the consequences can be pretty much the same or even worse sometimes for folks who get deported out of the United States. So I'm gonna start with some of the state protections that we have here in California. As I mentioned, I work at the office that's based in San Diego. Let's get started on that. So really quickly, we have SB 54 or the California Values Act that passed in 2017 and was and started being implemented in 2018. So what SB 54 does is basically just it limits the police or local law enforcement from collaborating with federal immigration agencies. So, for example, one of the limits is that police cannot share any personal information with immigration agencies. They cannot notify ICE or CBP when a person is about to be released from their custody, and they cannot transfer ICE or CBP. They cannot transfer people to ICE or CBP custody. That's one of the limits, but there are things that they also prohibit, not only just try to limit as far as we can see. One of the prohibitions is that local law enforcement cannot ask about immigration status or make any arrests for immigration enforcement purposes. They cannot use immigration agents as interpreters, and they cannot detain people longer than they have to in response to what we call an ICE hold request. It also creates safe spaces at some public spaces such as schools, hospitals, courthouses, libraries, and other public areas, just to make sure that people are able to access basic services such as education, religious freedom, and medical services. So we're gonna move on to the update on federal policies. And we're gonna start with Operation Streamline. Operation Streamline is not a new policy. It has been implemented, or programming has been implemented in other borders such as Texas and Arizona for more than 10 years already, and it's a really problematic way of criminalizing immigrants in this country. So, as I mentioned, this is not new, but it had never been enforced in San Diego. But sadly, in the summer of 2018, it was implemented here locally, and it's basically just an expedited process, criminal process in which folks are charged with entering the U.S. illegally. And it's a kind of like it was when it first started here in San Diego, and the way it works in other borders, it's kind of like a same day process. So In the same day, you have arraignment, plea, and sentencing hearings into one court appearance with groups that show up that are taken into court in groups of 10 or more at once. This means that, for example, someone who's detained trying to cross the border, let's say today, right now, around they'll be detained by Border Patrol, they'll be processed by Border Patrol. Probably the next day, really early, they're going to be taken into court. They're going to be able to meet with their federal defender. They'll have about an hour to talk to them and try to, so in this short period of time, in most cases with the assistance of an interpreter, the attorney has to gain their client's trust and be able to explain the process that they're going through and the consequences of the process and get them to make a decision on whether they want to plead innocent or guilty to the charges that they're being accused of. And then they'll be taken into court, and then the judge usually just refers to them as numbers and goes by one by one, trying to get their plea. And then they'll get a chance to address the court if they want to. In most cases, they apologize to the US for trying to cross and explain that they were only here trying to reunite with family, or they're trying to obtain a better life for their families and things like that. And most of them, as I mentioned, this is just an attempt to criminalize immigration. So most of them are just sentenced to time served. So it's basically a way to make sure that they have a criminal record for trying to enter the United States, even though they didn't harm anyone. Luckily, here in San Diego, there have been there have been several changes to the program. The federal defenders were great in opposing the implementation and making objections, so they would be on the record when they were defending their clients. And we also had the Bell Project, who came to San Diego and started working on trying to get some of these folks, especially asylum seekers, out of detention, so they can go through their proceedings and have a better chance of getting legal representation for their immigration proceedings if they're gonna be entering in those. And we as ACLU, we began a court watch program where we had our volunteers go and observe the proceedings and take notes of whatever they were witnessing and whatever they thought it was outrageous or whatever they didn't know. They were gonna be doing. So let me see. Yes, Monday. Okay, let me try to see how I can. Okay, great. So let's get this moving. Perfect. So as I mentioned, a lot of Streamline has gone through a lot of changes. So now we have kind of like a different version of what Texas and Arizona are seeing in their courtrooms. And right now, the status hearing is only, it's set for 4 to 5 days later, which gives attorneys more time to work, to meet with clients and discuss and make sure they were able to understand the proceedings that they're going through and the consequences that it's going to have in their immigration case if they are going to pursue one. So that was one thing that happened last year. Then we have the end of the safe release policy. And this is the safe release policy. Is basically the way that it worked is that immigration would usually, before they would let someone out of their custody, they will make sure they were able to contact their family or friend within the United States. And then after that, the family or friend would make travel arrangements to make sure the person would get safely to their final destination within the US. Late on the fall of 2019, we were notified by immigration agencies that this policy was going to end. And the next day, here in San Diego, we have what we call the San Diego Rapid Response Network, which is a network of local organizations that came together to create a hotline in which people, the community, could report immigration activities, and we will be able to send someone and verify the information and provide assistance in case that was happening, in case there were like any detention by immigration officers. So we got a call through the San Diego Rapid Response Network hotline, where folks mentioned they were seeing families who were stranded at the Greyhound station here in downtown San Diego. So this is kind of like a timeline of how everything developed. On the fall of 2018, we were, as I mentioned, we were notified that this policy was going to end. The next day, we get the call to the San Diego Rapid Response Network hotline, and then basically from that night until today, the San Diego Rapid Response Network has been managing a shelter, and by November of 2018, a few weeks later, we were able to, through a lot of conversations with local immigration agencies, we were able to create a collaboration. So now they're dropping off folks directly at the San Diego Rapid Response Network shelter instead of dropping them in random places and with no assistance whatsoever throughout San Diego. So that was kind of one of the successes that we had. And then we also created that same collaboration with Border Patrol in Imperial, which is a county that's almost 2 hours away from San Diego. They have a lack of resources there, so they don't have any shelters. And I want to mention, I just want to repeat myself. San Diego didn't have an immigrant shelter before the end of the safe release policy. So we created that collaboration with Border Patrol in Imperial. So they would drop off folks 2 or 3 times a week to our shelter in San Diego. So they would bring them for them to be able to receive the services that the shelter provided in San Diego. And then just so you know, more than 17,000 people have passed through our San Diego Rapid Response Network shelter since it began until the beginning of last month. So that was the second thing that happened. The third thing that happened was Remain in Mexico, or the MPP, or Migrant Protection Protocols, which we know they're not protecting anyone, but that's the name that the administration chose to give this program. So basically, the way it worked before, if you wanted to ask for asylum in the US, you could present at a port of entry and ask for asylum, or you could ask for asylum once you were in the country. So what this program does is that it forces everyone who's asking for asylum to wait in Mexico while they get their next court. So let's say someone is apprehended at the border, they say they want to ask for asylum, and then what will happen is that person will be processed by immigration around between 24, I think, to 72 hours, and then they'll be sent to Mexico. In this case, in our experience, to Tijuana, in our border, to wait for their immigration hearing, which can happen in, I think the wait time right now is between 2 to 3 months. So they'll wait in Tijuana for 2 to 3 months until the next hearing. They'll have to present themselves at the port of entry really early that day so that immigration can process them, let them in, and then take them directly to court, and then have their proceedings. Obviously, this presents a lot of concerns when it comes to due process and for people who are asking for asylum for the protection of the United States. So this policy began to be implemented in the Tijuana-San Diego border, and it was implemented on January 29 of this year. And then by the next month, a few weeks later, the ACLU, along with other organizations, we were able to challenge the implementation of MPP. We were able to legally challenge the implementation of MPP. And then, unfortunately, on April On April 8th, a federal court blocked the implementation of MPP, but the government appealed a few days later. So remaining Mexico is currently in place, and now it has expanded throughout throughout the border. So as I mentioned, it started in the Tijuana San Diego area. When it first began, it only applied to adults, and no family units were part of that program, and it only applied to people from Central America, meaning Honduras, Guatemala, and El Salvador. After a few weeks and months, it slowly started to include other folks. So currently, the way MPP is implemented, it includes family units too. It includes Spanish-speaking countries. So not only Central America, but we've seen folks go through MPP from a lot of countries right now in the last couple of months. And just so you know, and as you can see on the screen, we have a lot of issues when it comes to them being able to access legal representation. When you're going through proceedings, well, if they were going through regular asylum proceedings, if they were detained, that also presents a big challenge for them to be able to get legal representation. But obviously, it's easier for an attorney to go to a detention center within the United States and access their client instead of having to go to another country and offer the same services that they would. And that also creates a lot of tension, especially because of the recent harassment that immigration attorneys and immigration activists have received at the border, at the ports of entry by CBP. So as you can see, only 1.2% of the cases that were decided had any representation. 163 cases out of almost 13,000 have representation, which are currently going through proceedings. And we think that by now the number of migrants who are awaiting for their proceedings along Mexico's northern border is around 60,000. So, and the next one. Yeah, for example, in the case of San Diego, we only have 2 organizations who are providing legal representation for folks. We have Jewish Family Service and we have Immigrant Defenders, who they were originally based out of LA, but recently were able to hire an attorney to be based in San Diego and provide representation. But as you can imagine, that representation is really, their capacity is really, really low in comparison with the demand and amount of folks who are waiting their proceedings in Tijuana. And if San Diego, Tijuana is low resource, we can only imagine what that's going to look like, or what that's looking like in other borders such as El Paso, Juarez, and other places where this is being implemented. And the other thing that I would like to point out is that, for example, folks who are crossing through Mexicali, through Calexico or Imperial, they're going to be processed there, but there isn't an immigration court in Calexico, so they're going to be sent to the court in San Diego. So they're going to have to move from Mexicali, which they're being sent to, wait, and then move 2 hours to Tijuana to try to get to their court when their court is up. That's MPP. When it comes, the other thing, that recent trend that we have right now is the expansion of expedited removal. And expedited removal, as the name says, it's really an expedited process. And it's a really expedited process to get someone out of the country. It has been implemented for several years, just in what has been legally considered the border, which is 100 miles of every U.S. border. So 100 miles within the border with Canada, with Mexico, and both coasts. So all of, as you can see in the image, all of that kind of like reddish area is what has been considered legally the border, which is the 100-mile zone. So expedited removal used to only apply within that area, and for people who couldn't prove that they were in the country for more than 14 days. So what the administration wants to do now is to expand that and make it a nationwide implementation. So it wouldn't be limited to that 100-mile zone. And the other thing that they are expanding is that folks have to prove that they haven't been in the country for more than 2 years. So we don't know what this is going to look like when it comes to implementation. We know that in the border, it's easier for Border Patrol to try to determine that, especially if they're apprehending folks when they're trying to cross, which is mostly the folks who receive expedited removal currently, and also for folks who it also applies a lot to Mexican nationals because of the country's proximity. It's deportation proceedings can happen really quickly for Mexican nationals. So the ASOU, along with other law firms and with American Immigration Council, we are challenging the expansion of expedited removal currently in the courts too. And I think this is the last one. And then the other update that I wanted to mention was the Flores settlement agreement. So I don't know if you've heard about the Flores settlement agreement, but it's a court-approved settlement that provides basic protections for children who are in the government's custody. So it provides really, really basic protections for them. It places a 20-day limit for children so they can be held in unlicensed facilities. It establishes minimum guidelines for safe and sanitary conditions in detention facilities for children, and requires the government to provide children with basic needs like food, water, and medical care. And I know this seems really basic, but you may have heard in the news that recently we also had to defend the rights for children to have access to toothpaste and a toothbrush while they were in detention because they didn't think it was under the basic necessities of children. So as basic as the theme is really necessary, and it really provides important protections and limitations for the government to hold children in their custody. So last month, the Trump administration announced that they want to issue a final rule and override the Flores settlement, so it wouldn't apply anymore. In California, along with 19 other states, they are suing and challenging the Trump administration's abandonment of the Flores settlement. So we'll see how that develops. And I think that's basically the update that I have. I don't know if we're gonna do questions. I mean, we have time, so if folks just want to write in their questions, I'm happy to try to answer them too. And yes, one of the questions. So currently MPP, we haven't seen a formal document or seen like a reading criteria of who is part of who can be put into like MPP or remain in Mexico proceedings. So what officials have told us is that it applies to Spanish-speaking countries. That's the way they said it, and it also applies to family units now. It doesn't apply to unaccompanied children or Mexican nationals or individuals who might have a medical condition. But again, we haven't seen a reading criteria, so that's kind of like on a case-by-case basis. So are there like any more questions? Okay, So it seems that we don't have any more questions. I think you can see my information on the PowerPoint. Oh, okay. We have another question. So does ICE provide psychological services? No, it does not provide any psychological services. In fact, all of the medical services they provide, it's a little bit different. They do have a little bit more medical services that they provide for folks who are in ICE custody, but most of the people who are going through all of the, through MPP, through Operation Streamline, they are held in either Border Patrol custody or CBP at the ports of entry, and those are short-term detention stations. So they're only supposed to be there between 24, a maximum of 72 hours. So they don't have a lot of basic services that longer detention centers have under ICE. And again, not that ICE medical services are great in a way, but they do have a little bit more of services than people have at Border Patrol stations or ports of entry. Okay. Well, if there aren't any more questions, yes, a lot of the work that we do. So one of the questions is that we develop relationship with Border Patrol for San Diego Rapid Response Network. We did a lot of the work that we're doing right now depends on a lot of the local relationships that we have. It's a weird, it's complicated. We are the ASLU is the organization that does lawsuit against immigration agencies the most in the country, but at the same time, we know that we need to be part and we need to kind of collaborate whenever we can and be able to work on special cases and special situations that happen. That's critical under this administration. Things shift really quickly. New policies, new programs, new proceedings, new practices are being put in place almost every week. So we do have a fairly good relationship with local immigration agencies to try to work and avoid any harm, or try to work so that we're able to manage any situation that arises here in San Diego County. So far, so the question is for asylum seekers being released without court date, how long will it be until they receive one? So we don't, the ASLU, we're not a direct service provider, but we are in constant communication with our partners through the San Diego Rapid Response Network, who enjoys family services, who are attending asylum seekers. So all of the folks that have been put through MPP or remain in Mexico, they should all have a court date assigned to them. We've gotten a couple of cases recently, and I wouldn't be able to provide an update. I know Jewish Family Services is following up on that, but technically everyone who's put through MPP and is waiting in Tijuana, they should have a court date. And I think the non-agreement between Mexico and the US is that they would only give permission for them to wait 90 days. So their court shouldn't be set, their first court shouldn't be set for more than 90 days, because then they'll have to have another permit expedited by Mexico's government. Yeah. Okay. Well, thank you, everyone. It seems like we don't have any other questions, my information is on the presentation, so feel free to reach out if you have any other questions, and if there's something that you think we can help or support with. So thank you so much. I hope this was helpful and useful. And then again, you have my information, so feel free to reach out. Thank you.